presentation.
We are live.
We are live. Good morning. This is Senate Judiciary. It is January 23rd, 2024. Can you believe we're already towards the end of January? And we're making great progress. Taking up S-190 and relating to statements made by a child victim of offense involving serious bodily injury. So, Michelle Childs is going to walk us through some new legislative language, if we have it. It's draft 1.1.
Yes. So for the record, Michelle Childs, Office of Legislative Counsel, and you should have a strike all amendment draft 1.1 dated the 17th. And so just as a recap, you'll recall that S-190 is amending the court rules. It's amending the rules of criminal procedure with regard to depositions, and it's amending the rules of evidence with respect to the hearsay exclusions, and dealing with the issue of children in those particular cases, and providing for alternative rules in those certain cases. And there are currently exceptions when there are children involved in certain types of offenses who are the reported victims in these cases, usually around sexual abuse cases. And this would be, and the underlying bill is extending it to cases in which those children would be victims in cases involving serious bodily injury. You have a definition of serious bodily injury. I think I passed out last week to you. It's in 13 VSA 1021, that definition, and it's really used kind of throughout the title. So it's a term that is used frequently and that is known by practitioners. And so what was in the bill as introduced was language that the center had kind of put forward around extending those exclusionary rules to an offense involving serious bodily injury as defined in 1021. And then some of the discussion around it kind of came up around, the types of offenses that will be swept in, because what you have in the rule now is it usually will say the exceptions apply, and then it'll have certain offenses listed rather than something like a condition of the offense or an element of the offense. And so there were questions like, well, would this apply to negligent operation of a motor vehicle in Title 23 where you had, a minor who was injured or things like that? And so I think in talking with Jen at the center and talking with the sponsor of the bill, the proposal in front of you is really kind of a little, it's narrower, but really targeted what their original intent is, which is, and so you'll see on the amendment on page 1, on section 1, which is the amendment to the rule regarding depositions of minors, and you'll see that the current language is in sexual assault cases, and this would be adding sexual and serious bodily injury. Oops, that's not what I would, in sexual assault is, all right, that's a little typo, but we'll fix that. But you'll see what's added there in the substituted language is that instead of it referring to any offense that would involve serious bodily injury, it's just going to be in cases where there is an offense involving cruelty to a child that involves serious bodily injury. So you'll see the reference to the statutory offense for cruelty to a child, which is section 1304. And then it's further limited by it only applies to 1304B, because 1304A is a misdemeanor offense. 1304B is the felony offense, and that is only charged if the child suffers death or serious bodily injury. So, so you're taking out all the other offenses that might, or a child might suffer serious bodily injury, and you're just limiting it to these types of offenses. And so the same change is made in section 2 on page 3 to rule 804A, which is the hearsay exception. And so you see that language on line 18. And that's the change.
Michelle, one question. couple of years ago, we did a statute of limitations bill. And at the time, it was partly in response to what was happening at St. Joseph's, or what had happened, not what was happening, but what had happened at St. Joseph's and what had happened at Kern Hatton. And didn't we add serious bodily injury to that statute of limitations, or didn't we?
Well, the statute of limitations would apply to the particular offense, not an element of the offense. But I can pull up that law. Eric had worked on that one, so I'm not
to
familiar.
the statute of limitations on serious
Oh, okay.
because that was what we had done the statute of limitations for child sexual assault, like many states, although we went further than most states, and many states gave a year or 2 years in order to file the claims, and we just made it, no statute of limitations.
Right, so you're just curious as to what is the statute of
What we did
limitations?
was serious bodily injury in that, in response to the St. Joseph's and Kern Hatton.
Okay, all right, I can take a look at that, although the witnesses may, my guess is they were in on that bill and they may know that.
Call that recognized. But it was one of the elements there, particularly at St. Joseph's, it was testimony from the survivors. I'm just curious.
So also, I just want to note that one of the issues, Senators, that you had brought up was your concern about, whether or not you needed to take testimony from witnesses with regard to the application of the bill as introduced on how that would affect folks who are covered by the language in section 2 around folks who have a mental illness or intellectual developmental disability. And by narrowing it to cruelty to a child, I think you are kind of, you're narrowing it so that it's kind of focusing on the original intent, which is getting at the children's issue that the senator was
I think this
focused
amendment
on.
is consistent with what we had discussed in committee and concerns. So, is there any other questions from Michelle? Hearing none, we'll ask Jen Pullman, Marshall Paul.
Senator, I think that, I think Judge Donay needs to go before me because he has another commitment.
Oh, well, yes, absolutely.
Senator Clark just came in and said that they would like me in economic development this morning, if I have a few moments. So if I go next, if that's okay.
You're a busy guy. Come
We
on.
have our moments.
Yeah.
Thank you.
We always try to accommodate judiciary schedule.
Thank you. I just found out about it. She said, we'd like you to come over. So Tom Zonay, Chief Superior Judge. I've had an opportunity to review the revision, and it is a policy decision, obviously, for the legislature. And as far as the impact, it's clear, the language, it sets forth the policy. And as far as the impact, it is not a bill that I think would impact the judiciary significantly insofar as we don't see a lot of those cases where this comes up. But to the extent that it does, it is a case where this comes up, we have the existing resources to be able to address it as would be intended by the statute and rule change.
Thank you. Any questions in that lengthy testimony?
All right, thank you very much. Have a great day.
Enjoy the rest of your day.
We'll try. We'll be back.
We'll be back. We'll see you soon, I'm sure.
We'll be there this afternoon too, so it's going to be a big day in the State House.
Yeah.
Thank you.
Thank you. Now, Marshall Paul.
Excuse me.
I thought you looked better and you were feeling better
I
than the
feel
last
better and feel better, but I'm still on some therapy, so.
Well, take your time. No.
So I've just only in the last few minutes, I had the chance to look at the revised version of S-190, and while we certainly still oppose S-190. Our opposition is definitely not as strong as it was prior to the changes in this new draft. And I'll just address those the concerns that we do still have sort of briefly. First of all, the bill, at least as it was originally introduced, was a dramatic expansion of Rule 804A. The narrowing it down to the cruelty of a child statute only certainly narrows that expansion, but it's still an expansion of 804A. And I want to talk a little bit about the process of expanding 804A, because this is not something that the legislature typically does. Typically, the legislature writes statutes and the legislature does not draft court rules. In fact, there's a whole process for that. There's a committee on the rules of evidence and there's a committee on the rules of criminal procedure that consider these types of, exactly these types of requests, determine whether or not they should be implemented, draft the language, propose the language to the Supreme Court. The Supreme Court either promulgates the rule or doesn't. If it does, it then goes through the Legislative Committee on Court Rules. And so while the legislature certainly has the ability to rewrite a court rule, it's not something that's typically done. Usually it's done through the rules committees, which are composed of prosecutors, defense attorneys, judges, victims advocates, court clerks, and other people who have really specialized knowledge in the areas that they look at. So, for example, I sit on the Rules of Evidence Committee and on the rules of the Family Rules Committee, because Family Rules governs the juvenile courts. And those are my two areas of expertise. And so that's the work that I do. Expansion of the scope of Rule 804A has been considered by the Rules of Evidence Committee several times over the past decade. I was able to find minutes going back to 2013, which is before I sat on the Rules of Evidence Committee. I couldn't find minutes going back before that, but from 2013 all the way up through 2020, the Rules of Evidence Committee considered multiple times over whether or not to expand the scope of Rule 804A, and in each case they decided not to. And in fact, the last few times that it came up, not only did they not vote against an expansion of Rule 804A, but they couldn't even get a second to bring the question to the floor for a vote. It was that unpopular among all of the members of the committee. And there's a reason for that. And the reasons are clear when you start to look back at the case law interpreting the confrontation clause, because that's what this is really all about, is the confrontation clause of the Sixth Amendment, which provides that any criminal defendant has the right to confront their accuser face to face. And that's ancient law. That goes back actually before, I mean, normally I'm in here telling you about constitutional law going back to the 1700s. This goes back far beyond that. This goes back to the Magna Carta. It's mentioned in the Bible. It's in Hammurabi's Code. The very first laws that were put to paper include this right to confrontation. And the limitations on that right to confrontation that have been recognized by the US Supreme Court have been very limited, very narrow. The one that's most relevant here, the most recent case interpreting it, is Ohio v. Clark, which was a case about exactly sort of the question that's presented here today, except that it was not dealing with child cruelty or serious bodily injury, but it was dealing with sexual abuse, as the prior version of 804A was focused on, the existing version of 804A. And in that case, the court allowed the out-of-court statement of a 3-year-old who disclosed instances of sexual abuse to her mother to come into court, but the court was also very reluctant to, and very careful to explain that they were not seeking to expand beyond that they were ruling on one ground and one ground only, which was that testimony that came in was non-testimonial. It wasn't given for the purpose of incriminating someone or gathering evidence. It was simply a child talking to her mother. To expand beyond that, to expand to cases where we're talking about children who are not, who are experiencing something other than sexual abuse, hasn't really been tested by the courts, and it's not clear where that would go. When you look at Ohio v. Clark, that case was decided on a bare majority, and the Supreme Court has changed dramatically since that time. One of the things that gives me a great deal of pause when I read Ohio v. Clark and then take a look at this proposed language is that the main dissent in Ohio v. Clark was written by Antonin Scalia. And this was back at the time when the court still had Antonin Scalia, Ruth Ginsburg, Stephen Breyer, Kennedy were all on the court. Since that time, there's been a huge turnover on the court, and the court has been filled with people who are more like Antonin Scalia and less like Stephen Breyer and Kennedy and Ginsburg. And so if you ask me, this is pure speculation, but if you ask me if a case like this went before that court again, considering whether or not Ohio v. Clark could be expanded beyond the realm of sexual abuse and into the realm of physical abuse, I would highly doubt that it would pass muster, given that Antonin Scalia was so deeply opposed to expansions of these types of rules that allow essentially hearsay statements to enter court as if they are non-hearsay statements. And I think that alone should give us pause. I think additionally, when you start to look at, I heard that there was a lot of sort of discussion about where we stand in relation to other states that have laws like this. And I think some of the way that was presented was sort of inaccurate, because it's not true that, we are some crazy outlier by not having a provision that allows this. In fact, at least with the original language, not the revised language from today, if we had adopted the original language, we would, as far as I can tell, be the only state to have an exception that expansive. Only about a quarter of states have no provision allowing child hearsay into court whatsoever. But then when you look at the 3/4 of states that do, those provisions are actually pretty limited. Most of them look a lot like the provision we already have, Rule 804A. So, for example, some states like New Hampshire and Tennessee only allow statements to be introduced in that 804A context in non-criminal cases. So only in civil cases, only in cases where the standard is a preponderance of the evidence, not where the standard is proof beyond a reasonable doubt, reflecting the fact that there's a lot of questions about the reliability of this evidence. And those states, New Hampshire and Tennessee, their way of addressing that was to say, look, there's questions about the reliability. When we start allowing hearsay into court, we're definitely diminishing the reliability of our evidence. And if we're going to do that, we should only allow that to happen in cases where the evidentiary burden is not so incredibly high as it is in a criminal case. Other states like Rhode Island, South Carolina, and Utah will allow out-of-court hearsay statements from child witnesses in sexual abuse cases, but they'll only do it if those statements are videotaped. And that's because they want to sort of reduce the amount. The problem with hearsay is that it is one person repeating another person's out-of-court statement. And the idea was to reduce the amount of sort of layers of statement on top of statement and say, okay, we understand that there may be cases where it's appropriate to have a child's testimony come in without, without that opportunity for direct and cross-examination. However, that should only happen when jurors are able to look at the actual questioning and answering themselves and not be given sort of a third-hand account of it. Many other states just simply limit, like Vermont does, 804A to cases that do not involve physical injury. That would be states like Alaska, Arkansas, Massachusetts, Michigan, Mississippi, New Jersey, North Dakota. So when you start to look at it, there's actually really a minority of states that allow the kind of testimony in that the original version of S190 was allowing in. Now, the revised version of S190 has all the same problems that the original version does. It just narrows it down to a really narrow category of cases. And that certainly, from our perspective, is an improvement. Because the idea of direct and cross-examination has, for centuries, since before the sort of modern US court system, has been called by court systems to be the greatest legal engine ever invented for the discovery of truth. And so whenever we do something where we take away somebody's right to a direct or cross-examination, we are diminishing the truth-seeking ability of the court, and we're diminishing the accuracy of the determinations the court's going to make. And it happens that we're doing that in some of the most serious cases that we have. We're doing that in sex assault cases. We're doing that in child abuse cases. We're doing that in the cases that have the most profound impact on defendants' lives if they are convicted.
We have a question from Senator Blouse.
Yeah,
Or a comment.
I have a couple questions. One, when you referred to early in your testimony on the Legislative Committee on Court Rules, is that the Legislative Committee on Judicial Rules?
Yes.
Okay, I just wanted to make sure I was conceptualizing the Rights Committee. And then you also said that some states, I think New Hampshire requires that video be accompany this type of testimony from out of court. Would the Defender General's office be able to be more supportive if we did require a video accompaniment?
We would be more supportive, but just to be clear, that wasn't New Hampshire, that was Rhode Island, South Carolina, and Utah. New Hampshire and Tennessee allow these statements in civil court and in family court matters, but not in criminal court matters due to the differences in the evidentiary burden. So they allow it in when it's a preponderance of the evidence standard. They don't allow it in when it's a proof beyond a reasonable doubt standard.
Can I direct you to page 4 of draft 2.1, which is the current law, from line 11, 3 and 4. And I think current law,
Page 4, which lines was that, Your Honor?
4.
3 and 4, line
11. The child or person with a mental illness or intellectual or developmental disabilities available to testify in court are under Rule 807. And the time, content, this is 4, and the time, content, and circumstances of the statement provide substantial indicia of trustworthiness. Indica not of what we use, so I stumble on it. But doesn't that somewhat address the concern?
It does somewhat address the concern, but not completely. And I'll give you an example of what sort of the issues that come up around 804A hearings are. So if the state wants to introduce evidence under Rule 804, they have to give notice to the defense that they intend to do so. And then the defense requests a Rule 804A hearing. The Rule 804A hearing is where you test the evidence for indicia of reliability, and also test for indicia of coerciveness, and things like that. what that does is that serves to very severely slow down those proceedings. Those proceedings take a lot longer when you have to have an 804A hearing because the defense needs to get an expert. The prosecution regularly gets an expert. And you essentially have a mini trial within a trial about the reliability of the statements, the nature of the questioning, the methods that were used in questioning. And those cases, not only do those cases sort of make the case itself take longer, they almost, and I say this as slightly rolling my eyes as someone who often does appellate law, almost always end in an appeal because the decision that the judge makes in that case is extraordinarily discretionary. The judge has a lot of discretion to either exclude or include evidence based on Rule 804A, and judges make those decisions in very different ways. And there's not been a lot of guidance provided by our Supreme Court as to when they are abusing their discretion and when they are exercising their discretion appropriately. And so not only do you end up having sort of the trial within a trial in order to address the indicia of reliability, the nature of the questioning of the child, the methodology of questioning the child, and digging into the child themselves and what, are they a child who understands the difference between telling the truth and not telling the truth? Are they a child who understands the significance of telling the truth in this circumstance? There's an interesting study that was done recently that looked at 4 and 5-year-olds. And they were all 4 and 5-year-olds who went on a field trip together. It was a field trip to a police station. And they asked the 4 and 5-year-olds questions just a few days after the trip to the police station that were all very simple, just, about things they had seen at the police station, things they hadn't seen. And 3 out of 5 kids simply lied about stuff for no reason whatsoever. They weren't getting any benefit from saying something that wasn't true, but they were embellishing the things they had done and the stories they had heard and what they had seen at the police station. And this gets back to, I think this bill is actually really, in a lot of ways, connected to this committee's consideration of S6 last year, which was vetoed by the governor, which was the bill on interrogation, juvenile interrogation. Young people are eminently suggestible, and the younger that people are, the more suggestible they are. They often feel the need to answer questions in a way that pleases adults or that they perceive will please adults, even if that's not an accurate perception. And that's why it's important to give both sides the opportunity to both directly and cross-examine a witness in any case. But particularly when we're talking about children who are extraordinarily susceptible to coercion, manipulation, and, are very much open to making statements that are not true. So it's, from our perspective, Rule 804A itself is problematic because it really diminishes the quality of evidence that some of our most important cases are decided on. And any expansion of Rule 804A, we certainly oppose. I will say that the modification that was made here to limit it to child, cases where child cruelty is charged, certainly that's better for us, not because we don't think it causes the same problems, but because those problems are much narrower in scope if it's limited to one particular offense.
Senator Bahowski.
So my other question, and I'm not going to try to remember which state it was because I've already showed I'm not very good at that. But you also testified that there are some states that only utilize this if no injury resulting is so a less serious case.
I would not say a less serious case. In those states, it certainly applies to instances of sexual assault, which can absolutely be every bit as serious as cases of physical assault, if not more so.
Okay. Okay, so in those states, it only applies to sexual assault. It does not apply in instances of physical assault.
Sexual assaults and other types of sexual offenses. Sexual assault is pretty specific, and each state defines it differently, but all of those states limited it to categories of sexual offenses.
Okay, that's helpful. I got a little confused with the sort of no injury resulting. That made me think those were less serious crimes, but thanks for clarifying.
Okay. Anything else?
No.
Okay,
Thank
thank you. Jennifer, did you have some comments that you wanted to make?
Sure, Senator, I haven't prepared testimony, but would like a chance to comment, if that's okay. I might be a little bit all over the place.
I hate that.
Thank you, Mr. Chair. Thank you to the committee for taking this up as an important issue that is prioritized by all of you. I have a couple of brief comments. Certainly, I want to thank Attorney Childs for bringing some clarity to the bill that reflects certainly the intention that we had originally and have been working with Senator Norris on. And I think it deals with a lot of the issues that Senator Hashim had raised and Senator Chief had raised as well. The bottom line is that you all, this body, had made a policy change back in 2015 after the report that was issued upon the death of Desiree Sheldon and Peyton Gerard that said special investigation units must be the ones that handle these cases of serious bodily injury to a child. And as we move forward, we continue to treat children in a very different way in terms of how we protect them. With Rule 15, depositions, and 804A, hearsay exceptions. Rule 15, when these cases go south, it's because somebody who loves that child has said, I am not going to put my child in a room who's been seriously physically abused with the person who is alleged to cause that harm and subject them to the deposition testimony. So those cases go south because they don't want their child to go through that, period. With respect to 804A, there were questions raised about and comments raised about reliability. I just want to indicate for the committee that Attorney General or Assistant Attorney General Dominica Padula, who's the chief of the criminal division, noted that in fact that the reliability issues with respect to child statements is actually supports the rationale behind 804A. When she said on page 3 that a child victim's early communications are often highly trustworthy, and thus the rule allows omission of the child statements when there is minimal risk of fabrication. We're talking about non-testimonial statements to teachers, to parents, to daycare providers. They do not get to that level, and when a child makes that spontaneous statement, we're not talking about the child going into a police station and then reflecting 4 days later about what they saw or didn't see. This is about a child experiencing serious bodily injury, and I think we need to think about the rationale behind 804A.
Just a quick question. Are you making the argument that that those statements in those settings have the indicia of trustworthiness?
Yes, I think that, I mean, it's still up to the court to find that this exists. It's not an automatic, it comes in under 804A. The court has to find that. And I do want to reflect on Senator Bahavsky's comment about recording these interviews, recording other pieces, and that we do have SIUs and CACs that 95% of the time, all of these are video recorded, and then when they're not, they're recorded audioly, is that a word? They're recorded. And so, in fact, when that doesn't happen, I know that defense counsel has been able to really vigorously oppose and get those statements out because they say, well, we have this technology and you didn't use it. So we're going to ask the court to not allow that. So when I think about what Attorney Padula said, when we think about reliability and what we do in terms of allowing children who've been sexually abused to have their statements offered through 804A, there really is no rational, scientific, or legal difference in terms of a child who's been seriously physically abused having somebody who they made their statements to in a non-testimonial fashion to allow those statements in.
With respect to the rules issue, I just want to speak briefly to that, which was interesting because I was a part of the process back in the mid-2000s when we amended Rule 15, 804A, and then also 807 to include children who've been sexually abused. And back in, I think it was 2019, everything kind of circles back at this point, there was a question about amending the rules in terms of the definition of an individual who has an intellectual disability or mental health issue. And that question or that amendment was rejected because of the prevailing amount of case law that existed, and there was just not a willingness to go in that direction. At the time, I did testify briefly, and I did raise the issue of serious bodily injury of a child. And basically what I was told was that the legislature made these exceptions, the legislature can fix it. So I'm here before you again to say that when I testified before the Rules Committee, that's what I was told.
Are there any questions for Jen? Thank you.
Thank you very much.
Are there any other people that the committee wants to hear?
Can I make one brief?
Yeah.
I just wanted to be clear, when we're talking, I didn't talk much about Rule 15, which is about depositions. There's already a provision in Rule 15 that prohibits defendants from being physically present at a deposition unless by agreement of the parties. So the concern about a child being forced to sit in a deposition with the defendant who allegedly abused them really shouldn't happen unless the attorney for the prosecution has for some reason agreed to that, which I can't imagine why they would. But that's already in Rule 15B.
Is there any requirement for video?
No, but all depositions are recorded and transcribed. Audio recorded and should include.
So a jury could hear the video of the child. Currently in child sex abuse cases.
They would not be able to hear a deposition of a child because depositions are taken, they're testimonial and therefore couldn't come in under Rule 804A. You could use a deposition of a child, for example, as rebuttal evidence.
Jen?
And I'm not a practitioner, but I was a part of what we did in, again, mid-2000s, but under Rule 15F4, a self-represented defendant is not allowed to depose a child that's currently protected under E5. That would not include a child who's been seriously physically abused. So a pro se defendant, as I read the rules, is able to do that deposition.
And I was not talking about pro se defendants because they are a serious people. I mean, I think it's a tiny fraction of our defendants that are pro se. And frankly, by constitutional law, they're entitled to be pro se if they want and have to be given essentially the same resources that an attorney would be given. You can't, if someone has an attorney, you can take certain things away from the defendant and say, okay, the attorney can do the deposition, but the defendant can't be present. If someone is representing themselves, they essentially have to be given all the resources of an attorney.
Yeah, and that's part of the problem, by the way. There's a case in Bennington where the defendant was acting pro se and received all the material that the prosecution had, then went publicly, which an attorney couldn't do, as I understand. I mean, public by social media, not public in court.
I think an attorney, a defense attorney could do that. A prosecutor could. Prosecutors have a special ethical rule that prohibits them from publicizing a case. but a defense attorney is allowed to publicize a case.
So a defense attorney could, in the same way, divulge information that was provided.
They have to do it with the consent of their client. 1.6 on confidentiality says that a defense attorney can't disclose information except with the consent of the client.
But the pro se can, because it is the client.
They are the client, so yes.
So there's no.
There are things that can be done to prevent that. Things can be filed under seal, and for particularly sensitive documents, courts will often grant the request to file under seal. If something's filed under seal, then it can't be disseminated. And also, what I'm talking about specifically is criminal court. If the case is in juvenile court for any reason, then they cannot disseminate information about the case.
So if somebody's pro se, they couldn't give the information that's contained about the child in the, I'm a little confused. That's okay. I'm confused about the rules of evidence, how that all works.
I'm on the Rules of Evidence Committee, and I'm still sometimes confused by the rules of evidence.
I just wanted to add, so Ben's gonna pass out to you just so you can see, Title 12, Section 1, which is the legislature's authority to amend court rules. Which I realize that, Marshall acknowledged that you do clearly have the authority to do that. It's just a policy decision around whether or not you wanted to do that. You also, another way to do that is you can just create statute in Title 12, and then they have to amend the rules themselves to comply with what you have in statute. But you do have clear authority to be able to do that. And then also I do have a copy of the statute of limitations for crimes.
Oh,
And so I double checked with Eric, and he said with the bill that you're thinking of was dealing with civil cases on the statute of limitations. And so here's the statute that governs Title 13 crimes. And so because cruelty to a child is not specifically delineated for its separate own, I assume it's a 3-year, so it goes to the default. So you have a 3-year statute of limitations on that.
I remember that. Actually, I remember now the 40 years. Now we've got the 40 years. Alice Nitka mooning somebody from a school bus.
That was one of her favorite scenarios, wasn't it?
It wasn't Senator Nitka doing the actual.
Right.
No, it wasn't Senator Nitka.
Saying.
No, she did not. It
We don't
was,
want to confuse the YouTube
don't
audience.
want to confuse everybody by that. Yes, it was. She brought it up many times. All right, so Senator Wachowski had to go to Senate Transportation. Evidently, what's going on in transportation is
Very
is vital, but we do have a majority of the committee, ready.
I do have a typo on this and I need to send it through editing, but if you do want to vote it this morning, you can just vote on 2.1 and that'll.
Well, why don't we take a
first.
10-minute break so you can do your editing?
Okay.
And then we can have a vote, hopefully Senator Wachowski will be back.
Okay.
She wanted to bring up something about
Thank you.
Thank you. He's not scared.